BOT meeting at this time. Thank you for giving us the time for the executive session. We did not finish with audience participation. Is there anyone else that would like to step up? Patty?
Oh, there we go. Thank you. Patricia Matoliak, 944 Pecan Circle. I just want to speak briefly on the article about the proposed ban on beverages, from what I gather now, from the pool. I understand and support the reasonable safety rules like restrictions on glass and alcohol. However, a complete ban on all beverages goes significantly further. And it limits how we use the facility that is a communal facility. This type of restriction does not appear to be tied to safety or maintenance, and it raises a concern that residents may be effectively required to purchase from on-site vendors in order to use the pool comfortably. Moving forward, I just respectfully ask the board to identify the specific authority in our governing documents for this rule and explain the legitimate need for board restriction. Sorry about that. I don't like talking in front of people, but thank you for listening and thank you.
Thanks, Patty. Anyone else? Rich, you've already been up, Rich. Yeah, thank you. All right, at this point, we're going to close audience participation and go on with the agenda. We have 10 would be consent. We have none. Unfinished business? None. So on to new business. Mr. Shoshone.
The Barefoot Bay Policy Manual, page 22, states beverage laws and license regulations forbid outside alcohol beverages of any type from being brought into the district facilities or consumed therein. Therefore, alcoholic beverages of any type consumed on the premises must be obtained from district facilities. In addition, the Barefoot Bay Policy, page 29, states the state of Florida law prohibits bringing in and consuming alcoholic beverages on premises unless purchased from the district. Containers carrying alcohol may not be brought into the pool area. Persons with suspicious-looking containers may be denied entry into the district pool areas. Persons with suspicious-looking containers who refuse to allow staff to inspect them may be required to leave the pool area, which is inside the fenced areas of pools 1, 2, and 3, including the lounge, lakeside picnic pavilion areas, and may be subject to suspension of their social membership privileges. Furthermore, the Barefoot Bay Policy Manual, page 38, states bringing alcoholic beverages to district facilities is prohibited. Where permitted, all alcoholic beverage purchases must be provided by the Barefoot Bay Recreation District. In the Barefoot Bay Policy Manual, page 29, states, the pool host or other district employee has the authority to check bags or coolers for prohibited items before access is granted into the pool area. A safety compliance monitor position, which is formerly known as the crowd monitor, was created in fiscal year 24. This position's responsibility of highest priority is to ensure there is no illicit alcohol within the pool number 1 and the Barefoot Bay golf course picnic areas. In an effort to comply with the aforementioned state laws and the Barefoot Bay policies concerning the possession and consumption of alcohol within the pool 1 and the Barefoot Bay golf course picnic areas, Barefoot Bay staff is requesting the Board of Trustees to consider the following proposed additions to Barefoot Bay procedures to assist staff with successfully fulfilling their job duties and responsibilities. And before I read these procedures, this is draft language. This is not a final language. This is just draft language for the board's consideration and discussion purposes. Number 1, the pool host or other district employee has the authority to visually inspect, with consent, beverage containers, bags, coolers, backpacks, knapsacks, cases, purses, and all other similar accessories for prohibited items before access is granted into the pool number 1 and golf course picnic areas. If consent is not granted for a visual inspection, then access will be granted into these areas sans the accessories. Number 2, no beverages may be brought into the pool number 1 and golf course picnic areas, with the exception of beverages in unopened and manufacturer sealed clear plastic containers and cans. Staff requests direction from the Board of Trustees. And as the chairwoman stated earlier, as you can see, this language does not apply to any food whatsoever. That was not brought up previously. Again, I want to make that very clear. This has nothing to do with food at all. And also to point out, the language, again, is allowing beverages to come into that area. The requisite would be is that the beverages would need to be coming in a sealed, clear plastic container, which is manufactured sealed. So, can also. Yes.
All right. For discussion, two things for me. I want to make clear. I'm not sure about the clear plastic container, because if you have an unopened can of Coke, that's not clear. And I think you brought that up before, Ed. And then access will be granted into these areas without the accessories, meaning we would ask them to leave their bag there with the host.
No, you wouldn't be needing to, if somebody wanted to leave it with the host, that's up to them. That would be their choice. The individual that's wanting entry can leave the item at home. They can lock it in their car. So anyone that wants to enter in will be able to enter in. So no one's stopping the individual from coming into those areas. It's items that they are carrying with them is what may not be allowed into the area. But
Right.
the individual is able to come in.
All right, but if consent is not granted for a visual inspection, then entry will be granted into that area of the pool without the accessory. So as you're saying, they could leave it in the car. Can they leave it with the pool host if they're not willing to consent to the inspection?
Right. Yeah.
Okay.
So, and a real clear, the clear plastic, if you have, Coca-Cola in there, the container is still clear plastic. The substance in there is not clear. The container is still clear. That's all what that is saying.
Not a can, though.
I'm talking about the plastic.
Oh.
I'm talking about the plastic. I'm talking about
All right. Well, the plastic container is clear, but the iced tea, as long as it is.
Madam Chair,
As long as it's sealed, that makes a difference.
Good.
Madam Chair,
Yes, sir.
can I move that we table this until after a town hall discussion when we can have an appropriate dialogue back and forth with the residents?
Yes. I'll agree with it.
I need a motion.
Make it.
I move that we table the decision on beverages in the pool area until after a town hall meeting when the residents have a chance to have dialogue with us.
I'll second it.
All right. It is going to be tabled until our town hall, which is.
We just
Oh,
need
let's vote on it. Aye.
Aye.
Nay.
Good.
Motion is carried.
4-1 with Bruce,
Yeah. I'll go with it.
so 5.
Yep, hold on. The town hall.
Yeah. I'd still like to make one little statement on that before we leave it, is because I still believe, so we'd have it all for our conversation the next time, but keep in mind that staff should be allowed to set policies and act in a method to safeguard our liquor license. It's a real shame people try to get around county
Just a
laws,
second.
Barefoot Bay policies, and try not to contribute to the revenue of Barefoot Bay. I do feel snacks and non-alcoholic beverages are fine. You just need to come up with the proper rules of engagement, and I would strongly suggest you don't offer to leave the bag with a pool host. And then you get into the problem like the pool host said.
That's, I agree, but
Right.
that's why this is draft language and why we want to
Yeah.
sort out these ideas.
I'm good with
Because I
letting it
think
go.
Joanne mentioned the liability of some of this, and I think it needs to be discussed. So we will, if you are in agreement, we will post this for our town hall. Yeah?
Yes.
Okay.
Chairwoman, if I can ask for a point of order. Chairman Amos, how did you, or Trustee Amos, how did you vote on the motion? We're a little unclear.
With it.
With it? Okay.
Make it unanimous.
Thank you.
I don't want to be a stick in the mud.
All right, we'll move on to Crystal Bay gated access to Barbary Street. Mr. Grunau, this is your new business. Do you want to step? All right, Kent will read it, and then I'd like your information.
Okay. Trustee Gruno requested this item be placed on the agenda for discussion of the Crystal Bay gated access Barbary Street.
Okay, I was riding around Crystal Bay, and I was back on the back end of Topaz Avenue, and we are looking at right there, Topaz on Crystal Bay side, and then over here is our pool, down here pool, and then right here is Barbary Street, and there's the dead end. Now, if you'll notice in this picture, this was a emergency exit that the developer put in their plans because, as many of you know, Crystal Bay has one exit, Santa Drive, and about 2 months ago, a freight train stuck out there for 6 hours, and they could not get any emergency equipment in or out. Okay, again, over here is the dead end. Over here is Crystal Bay. You'll notice that the width is a little bit wider between that and these. All right, let's go for the next one, Kent. This is the, oops, which one's he going to pick? There you go. Now, this is on our side, and this is the end of Barbary. There's 3 of these nice, cute diamonds there. You'll notice that nothing has been done on our side, and to the best of my knowledge, this area is owned by the county. That's not owned by Barefoot Bay. You'll also notice that they've put in a brand new gate. All right, and then next one. This is what it looks like on the other side. They put in the brand new gate. They've put in all kinds of crushed rock, and my picture doesn't show it, but they built a ramp over the sidewalk, sort of like a driveway. It's not a street cut like you would see a street. So I think that's good news. Lynn and Kent have done some research on this. This still belongs to the developer. However, sooner or later, the question I asked was, who was dumb enough to approve that place? It belongs to Grant Valcaria. It does not belong to Brevard County. So Grant Valcaria is the one that approved this development. So right now, this is an ongoing type situation. The developer has not handed this over to either the HOA or Grant Valcaria, but I was in the Air Force for 22 years. We had a slogan, fly ahead of the mission. And so one of the things, this is just so that we stay aware of this, and Kent, you were saying that, go ahead, you tell them.
From communication that Barefoot Bay staff had with Grant Valcaria, they indicated that the HOA for Crystal Bay had no intent to open that except for emergency purposes, and that the HOA was currently in communication with their legal counsel to define what emergency purposes would entail. From looking at, these photos, information pertaining to the gate here, it appears as there is really no intent for that to be open on a permanent basis. I always put a caveat that anything can happen, but again, everything points to that this is mainly put in there most likely as a requirement of Grant Valkyria's development codes, that since Trustee Gruneau pointed out that there's only one entrance, ingress and egress at the front of this community, and that most likely this was a code requirement that there would be an emergency opening at some point, but especially at the back of that community for emergency purposes.
Jeff, is our side, is that district or is that owned by the county, that piece of land owned by the county on our side,
As far as I know, that county owns the roads.
the road?
So that,
The road,
our
but I'm talking
side,
about that where the emergency gates would be going, that piece of land there, is that owned by us or is that by the county?
go ahead, Ken.
So on our side, it appears that it looks like right away there, it belongs to the county, from what we can see. On Crystal Bay's side, that strip between the two homes shows that it's Crystal Bay's property. So it's not. However, it's always a possibility that an easement could have been granted to the Grant Valkyria, as an example, but it's showing the ownership of that strip is the HOA or Crystal Bay. So I'll say.
So they want to use that as an access for anytime anybody wants to go through there, or is that would be that just be only granted during an emergency?
What,
I think they have to determine what an emergency is
Yeah.
first.
yeah, this is what I said to Kent was, in sports term, best defense is a good offense. Fly ahead of the mission in the Air Force. We know it's there. We know they want to use it in an emergency. God forbid, if there's an emergency and the freight train sat out there for 6 hours, I want the fire truck to get to my house. But on the other hand, I think we should be proactive in making sure that we have a memorandum of understanding or a memorandum of agreement of who's got the key, who uses it, and what do they use it for. And that's why I brought that up.
I agree with what you said. It's good to have an emergency. Getting this, like you said, if the
Garrett?
train is stalled there, ambulance has to come. We can.
It's so I am just now on the property appraiser's website on their map view. I haven't reviewed the plat to see. It does look like the egress on the district side is county right of way, so the county controls it, is responsible for maintaining it. The district wouldn't be able to, without authorization from the county, make any improvements in the right of way because the county could come in and take it all out the next day and charge us for it. But the side of the egress on the Crystal Bay side is owned by the Homeowners Association. I think it's almost a certainty that that is a requirement, a condition of the development, because there's only one point of ingress and egress at the front of the community. But I think if you were looking to get ahead of any sort of issues, I think it might be appropriate talk to the Homeowners Association about, like you said, who has control of the gate, and we can ask if they can notify our staff when the gates open and things like that. Might also ask the county to post additional signage there that it's not a, it's not a through street, right? It's not an actual road that can be traversed. And it's for emergency purposes only. I think those signs are frequently used in these situations. So,
Garrett, can the county come in and say, we're going to put in a street there?
I doubt they would put a street in. I don't know if they would put improvements in, like the crushed stone that we see there. It all depends on what utilities are under there. It also looks like there's a small stream, a culvert or some sort of stream. Anytime there's water, everything takes 10 times longer. But certainly, if that's something the board wants us to inquire about, we can see. But I would guess probably not. But it doesn't hurt to ask.
I'm fine with that.
Yeah, as long as we just stay vigilant, that's,
Yeah, we'll have to find out what our options are if somebody one day just decides to cut the lock off and open the gates.
Well, it also, I know the district has many other exits as well, but, it is nice to have an emergency access point for us as well. So.
Ken? I'm just wondering where we go with this. Is that something that you would look into with their HOA, or?
So is the request, what's the specific request?
I was just going to say that, one, we know it's there, two, we keep an eye on it, and three, I think Garrett gave us some very good legal counsel, and then we just need to be ready to take action if we have to. I guarantee you that if it ever got opened and people started using it as a shortcut to Micco Road, you would not see the end of traffic through there. And so what I'm basically saying is, when I went by there 2 months ago, old gate, no improvement. Now, new gate, improvements. Just something we should be aware of and keep our eyes on.
Okay. Thank you, Mr. Gruno. All right. I'm going to move on to the next point on the agenda, and that would be our manager's report. Mr. Shoshone. Okay.
For our finance department, the assessment received to date is 86.3% collected, or $4,202,402. For our resident relations department, the ARC meeting of March 24th, 2026, there were 15 consent permits, and they were all approved. 14 other items, all approved. The violations committee meeting of March 13th, 2026, there were 5 cases that came into compliance prior to the meeting. 3 cases, the DOR is working with the homeowner, and 8 cases found to be in violation. For the food and beverage department, on Saturday, April 18th, Barefoot Bay brings national and touring artists, the Shaylin Band, to the lake stage from 6 to 10 p.m. The Shaylin Band can shift from soul, blues, and funk to rock with their highly energized live show. The Shaylin Band brings passion, heartfelt stories, and a vibrant production of professionalism to the stage. For entrance to the show, there is a $10 fee sold at the pool number 1 gate in exchange for a $10 voucher for food or beverage to be used that day. Building A is reserved as a backup to the outdoor stage in the event of inclement weather. A Mother's Day brunch will be held on May 10th, 2026 from 11 to 1 p.m. in the lounge lakeside area. During the brunch, Royal Inc. will play popular songs with a reggae twist. Tickets are on sale now at the 19th hole, the lounge, and in the administration building. For our property services department, there are a lot of work being done on the pools. The department repaired the pool number 1 pavers, repaired the pool number 1 area electrical issue, power washed the pool number 1 area picnic tables, repaired the pool number 1 entertainment area concrete, repaired the pool number 2 heater, repaired pool number 3 ladder, repaired the pool number 3 umbrella, repaired pool number 3 office doorway threshold, and replaced the pool number 3 pump. He also repaired the building A kitchen faucet, repaired building A courtyard pavers, performed repairs and maintenance on the lawn bowling facility irrigation system, assembled and installed memorial bench at the pickleball tennis courts, repaired tennis courts mobile bathroom toilet, cut down and removed tree encroaching into the canal, repaired beach shower again, repaired the floor cleaner, delivered an animal trap to a homeowner, trimmed dead palm tree branches throughout the district, repaired the Miko RV storage lot gate, reinstalled shopping center parking lot car stop, power washed, replaced rotten wood, and began painting building D&E exterior, repaired the 19th hole interior drainage issue, repaired the Brightview maintenance area water line, replaced the Brightview shop rotten wood, and finally filled in a ground depression on the golf course. For the Golf Pro Shop department, congratulations to our 2026 Barefoot Bay Golf Course Club Championship winners, Janet Rafferty, the 9-hole Ladies Club Champion, Raylene McSally, the 18-hole Ladies Club Champion, and Earl Martin, Men's Club Champion. Thank you to the 84 golfers who participated in this year's competition. The spring golf clinics are underway with Tuesday, April 7th, being at capacity. Thank you to all that attended. These clinics are free of charge to Barefoot Bay residents and golfing members. A schedule of times and subjects has been posted in the peak at the week. Residents stop by the Golf Pro Shop to take advantage of our spring sale through April 30th. Clearance items are marked at 40% off. The 2026 Barefoot Bay Junior Golf Program will be conducted June 1st through June 20th. Applications are available in the Golf Pro Shop. Call 772-664-3174 for details on clinics and general golf course information. For our maintenance of the golf course, on our greens, needle tying and spiking was completed to help open turf to let roots breathe. Weak areas on greens continue to be filled with green sand and myeloganite to help speed up recovery and to keep a smooth, plain surface. Foliar liquid fertilizer with a contact fungicide was applied to help keep turf healthy and disease-free. Weeds continue to be spot-treated and hand-pulled around greens and tees. All weak areas were prepped for the club championship. All greens surrounds have been treated with a broadleaf herbicide. For the tees, granular 15015 was applied to tee tops to help fill in divots and to help perk up the Bermuda grass. Daubing and hand pulling of weeds around tees is helping ensure we have no encroachment of unwanted species. Rotating tee locations is helping to minimize damage. For the fairways, granular 15015 has been applied to a few select fairways with mole cricket damage. Scouting for mole crickets continues. More applications will be put out to ensure we have a minimal damage from crickets this year. Spot weed treatment on the goosegrass continues to help kill and prevent the weed seeds from spreading and germinating.
I have a question, Kent. Are we ready to start our summer slowdown plans at all?
And that would be for food and beverage?
Yep. Yep.
Staff is prepared to do so.
Okay. All right. Anyone else? No? Anything?
Closing remarks?
No, if you have anything to say to Kent, if you are looking for anything. Okay. Okay. I'm going to go on to our attorney's report. Garrett?
Thank you, Chair. A couple of updates on some of our active DOR cases. On April 20th, I have a hearing in the afternoon on a motion to tax attorney's fees and costs. As you all know, the district recovers the attorney's fees in all of our DOR cases. We have a resident who has still not complied with the court's order, is still in disabeyance of the court order. And so aside from those ongoing hearings that we have for this particular address, which is at 401 Osprey Drive, we also have a motion to tax attorney's fees. I think the attorney's fees in the case are like $3,000 or $3,500 at this point. They're only going to keep going up. So that'll be a lien that'll run in the district's favor. We also filed a motion for final default judgment in the case involving 856 Laurel Circle. We actually did that this morning, so that case is moving along nicely. We have motion in all the other cases we have active right now. I think we have 10 active cases right now that are all going well, and we're looking forward to filing more here shortly. Wanted to give you all, or rather, Madam Chair, if this is an appropriate time, I think I heard there were comments, and I know there's a lot of concern from folks. A lot of them are here today about the ongoing litigation the district has with Brevard County concerning the interlocal agreement that was signed in 2020. And so I did want to take a moment, if it's okay with the board, to address a few of the points that got brought up. And I'll speak directly to the folks in the audience here. Just a few things for you guys to know to resolve some questions. I know a big one is how much does it cost the district to do this litigation, right? How much is our firm making from the litigation? The answer is not $1 more than we would have otherwise, because our firm has a flat rate arrangement with the district where the district pays our firm the same amount every month, no matter how much work we do for the district, which is quite a bit. So it's not an additional cost for the district, even though I spend a substantial amount of time on this particular matter. The next question I heard, or rather I heard during public comment, a statement rather that the assessment cap here is 3%. That's not exactly correct. The assessment cap is tied to the change in CPI, or the Consumer Price Index, year over year. So if the CPI from last year to this year was 6%, the cap would be 6%. The following year, if it goes up 3%, the cap's 3%. So it's variable. So it's not just a flat 3% cap. The other thing I'll mention is that I can't really talk a whole lot about really our legal positions beyond what has already been filed, and the complaint. You can read everything in the lawsuit so far. It's all publicly available at the Brevard County Clerk's website. But I can share with you that the district tried really hard to resolve this issue without having to file a lawsuit. We had informal meetings with the District 3 Commissioner. I met with her twice. We had the then Chairman Amos meet with her, and District Manager as well, explaining why the district wanted this agreement to get voided by both parties. She and the county attorney expressed that they would like to see this just get handled by the courts. We didn't like that answer, so we actually, pursuant to a very particular Florida statute, it's Chapter 164. It's called the Florida Governmental Conflict Resolution Act. It's specifically for when governments butt heads and have a disagreement. There's a very particular method to go about in a very public way so that there can be public input resolving those differences. The county we passed a resolution to that effect last year. It was all noticed. It was on the agenda. I'm sure you can go back and you can watch the video on it. Unfortunately, the county didn't like that either, and again, they thought that would be unproductive, and so they asked that we go ahead and do this friendly lawsuit so we can figure out, whether this agreement's legal or not. Which, of course, we contend it is not legal, and there are a few really good reasons why we think that. I want to preface by saying this: the direction I got from the board, which the board authorized the lawsuit at a public meeting, we talked about it for months and months and months leading up to that vote, is not to get rid of this agreement because the board wants to explode the assessments. It's just so that they can retain control over the process themselves. Because, of course, as I'm sure if you've read the interlocal agreement, you know that if the district needs to increase assessments beyond the cap, let's say there's no inflation year over year, or it's really low, like 0.5% or 1%, but there's big maintenance projects or other things that you all want from the district in terms of delivery of services or new services, new amenities, things like that, we'd have to go to the county commission, and they would have to vote. A supermajority of them would get to decide whether or not we get to increase our assessments beyond the CPI. And 4 of the county commissioners don't appear on your ballot when you go vote, which the board saw as an issue, and which is why they gave me direction to go and get the agreement invalidated. But I did want to confirm too with the district manager what the anticipated assessment rate is this year, even with the understanding that we're likely going to succeed in the litigation. So
The FY27 proposed budget was delivered to the Board of Trustees last month with a recommended assessment of just under 2.7%. Staff has not recommended anything other than that, no higher amount. The proposed budget was built on a assessment of, again, slightly under 2.7%. And again, say it again, staff has not recommended or suggested to the trustees to have any amount above that for FY27.
Thanks, Kent. And I'll close with this, just to put it into context. When we were talking to the county about resolving this matter outside of a lawsuit, which again was our preferred way to handle this, one of the items that the then chairman, Bruce Amos, brought up was that since I think like 2008 or 2009, since the district began collecting its assessments on the tax roll, that the district's assessment rate has never, year over year, exceeded the CPI. Even before this cap was in place, it's never exceeded the CPI. It's actually trailed the CPI if you compare it year over year from that point. The reason why the district had to agree to this in the first place is the former commissioner, John Tobias, in the middle of COVID-19, when there wasn't a lot of public input in meetings, particularly in Brevard County meetings, they were all, or a lot of them were remote. They wanted to take away the district's ability to collect via the tax collector. And I heard a question during the public comment period, what would it look like if the district went back to collecting directly, right? So you pay the district the money instead of it being on your tax bill. The first issue is that costs a lot of money. The district doesn't have the staff right now to do that. It's incredibly inefficient. I'm sure everyone in this room pays their assessments on time. You likely take advantage of the discount you get if you pay early. The kicker, of course, when at the bottom of your tax bill, you know that if you don't pay all of your taxes, including your property taxes, your fire assessments, right, your district assessments, you can lose title to your property. There'll be a tax deed issue against you. That is a very powerful penalty, and it does not cost the district a single dollar to enforce that. That's part of the system. We pay the tax collector 3% of assessments, but boy, it's worth it. It saves us a lot of money. And if we started doing direct collections, the district would have to, if someone, let's say, didn't pay their assessments, we'd have to file record a lien against their property. And we'd have to go through the foreclosure process if someone didn't pay, which would cost thousands of dollars. The district would have to hire a new separate law firm apart from our firm to handle that, because that'd be a full-time job. A lot of folks live here. And so, with all of that in mind, the county still pushed way back in 2020 to get this agreement done. That was their consideration, that they were going to remove a ballot initiative to question whether or not the district should even be allowed to collect through the tax collector. It would have been really bad. And we talked to the county about this and why the cap really wasn't a great idea. Or at least the cap might be a good idea if it's in the hands of the folks that y'all elect every year. But they said, file a lawsuit and we'll figure it out in court. So that's what we did. So we tried to work it out. We have a very good relationship. I have a very good relationship with the county attorney. And so, like I told the board, I think this will all be resolved by the end of May. And then from there, it'll be up to the board what happens. So, I don't think I missed anything. Yeah, I think I covered everything. So,
And there is a state statute that allows special districts to have their non-ad valorem collected by the tax collector.
So yes, and it's referred to as the uniform method of collection because everyone does it. But interestingly, the state statute that allows the county to create the district and the district's charter, which is the county's ordinance, so the county's own law, says we have that authority. And so, it's unfortunate that back in 2020 everything happened, but it would have been a disaster if it would have went to a vote, and there would have been a lot of legal issues to parse out even then. But I think that's why the board back then signed this agreement, and I think wanting to get control of that back to the districts, back here is a noble and it's a good thing to try to accomplish.
Thank you.
Thank you.
Madam Chair, I have some more information I can tag on to that, so if you want me to do that, or just go ahead with the...
No, I agree. I also wanted to say that I believe previous to us going to this collection method, we were only getting like 64% of our assessments in. And now we're at 99.8 or 9 when we're done. So, go ahead, Bruce.
All right, well, I'll do this, and if you want me just to go right into the final. But so I wrote this one for the board and for most of the people out there, so I know you're all going to come to the town hall meeting because you're still interested in this. So Here's what I put together. So, have you considered this? The duly elected trustees for BBRD during the yearly budget meetings increased assessments by an average of 1.48% per year for the period of 2006 all the way through 2021. When the county commissioners, 4 of the 5 that are not elected by BBRD residents, inserted themselves into the BBRD's budget process and forced a cap, we call it a floor, on the trustees tied to the CPI, BBRD's assessments increased by 19.74%, which is an average of 4.94% per year. That's only 4 years. So let's summarize. The Board of Trustees, when in charge of the assessments, as the charter states, has increased the cost by 20.74% over a period of 14 years. The commissioners have caused an increase to assessments by 21.19% in just 4 years. So you want to keep them in our budget process? And by the way, a gentleman said nobody voted to do this lawsuit, but nobody voted when the cap was forced on us. So you want people to run your budget who have already raised your base water charge 74.14% in just 5 years. The figures I'm quoting are from my own water bill. If you want to see it, I have it with me. I'm only giving you the base charges. You know, if you don't use any water, or if you are not even here for a few months, it doesn't stop. May the 5th, 2021, base charge for water was $15.10. Sewer was $32.52. Total of $57.62. That was in 2021. 4/4, last week, the base charge for water is up to $25.12. Sewer was up $54.11, a total of $79.23. That's an increase of 66.38%, an average of 10.7 per year. They also increased, by the way, the usage fee. And when you actually do use water, that went up 66.38% in that same time period. And to throw in for Jeff, they also increased the fire tax 37% in 1 year. So no matter what the experts on the false book says, the board is attempting to take back control of the BBRD finances that was allegedly illegally taken by the county commissioners. The board is not trying to get around a cap. Personally, I think a cap may be a useful tool for our budget process, but it must be set up by the Board of Trustees that you all elected and with the recommendations of the owners that can come up during our town hall meetings, not an outside agency that has no right to do what they did. So I think that's all I have on that. And I still have some incidental remarks if you wanted to just do that.
You go ahead, Bruce.
It's only one page. And if anybody wants to know, I have all those records if you needed to look at them. So my incidental remarks: to resident Gene Lively, I got an email from, and other residents I got an email from, and to the board. I've had a meeting with a representative of a solar hybrid heating company for pools, and we'll be getting basic information back of what is needed, where the panels can be placed, etc., and estimates to integrate solar with our propane heaters. He didn't see any major problems implementing the system. Hopefully I'll hear back before their next budget meeting on the 16th, I think that is. So I'd like to thank all who attended, and especially those who stayed to the bitter end. Don't forget the Board of Trustees will have 2 3-year terms to fill for 2027. Anyone interested should start getting information together. Go to the Brevard County Supervisor of Elections website. They have guides and forms needed, as well as all the dates. The qualifying period for the 2026 November election of the special districts is noon Monday, June 8th, 2026 through noon Friday, June 12th, 2026. Your paperwork must be filed during that week, and June is soon. Thank you.
He's a poet and don't know it.
Tells you my feet are Longfellows. All right,
Jeff?
back to you.
Okay, first, thanks everybody for coming out. We got a couple pivotal meetings coming up. We got a budget meeting coming up. We got a town hall, got another BOT, so appreciate people coming out. On a more happy note, anybody that's been on the 8th fairway or back by the 8th fairway, I don't know if Bill's going to be real happy about this. There were 50 whistling ducks back there this morning. They were doing their thing.
Did you all whistle at the same time?
Yeah, they were back there carrying on. So I'm guessing it was good that it was walking only today. So if anybody hasn't seen the whistling duck here at Barefoot Bay, back on the 8th fairway having a blast. And then the last thing is a point of pride. The American Legion State Commander, she's going to be visiting Barefoot Bay tomorrow. We are a very small Legion post, and for her to come by is a big deal. They want to see our Veterans Gathering Center. I think the board and the residents, that's a point of pride. Thanks.
Thank you, Jeff. Ed?
First, I'd like to thank everyone for coming, giving us your opinions. We do listen. When it comes to alcohol, going into the pool areas and stuff, we have to manage that. It's required by law. I'm hoping we can have respectful dialogue at the town hall meeting about this. I mean, we can't drop the policy and say, okay, just bring in whatever you want. Because what would it look like if we lost our liquor license? Do you think anybody would be going to the pool? You think you'd have bans? Wouldn't happen. So be respectful and understand we have to do some of this stuff. And I don't agree with everything that's on here, and that'll come out at the town hall. But thank you for coming. Looking forward to the town hall.
Thanks, Ed. All right, Mr. Klosky. Don't forget Cindy.
Thank you, Cindy, for all your hard work. I want to thank DOR, Sally, and all them for all their hard work. The finance department. And I want to thank each and every one of you people for coming here, putting your input in. It'll be worked out. And I don't know if I remember everybody, but whatever it is, thank you anyway. Actually, all you board members helped me out because I have to talk less. So, thank you.
Thanks, Joe.
What was that remark?
Annie said, thank God, Joe.
Oh. There's a guy in the back wants to raise his hand. I don't know if he wants to go to the bathroom or something. No, I'd like to mention something.
Not at this point, sir. This is our remarks. Yeah. I want to say thank you to my fellow trustees. I appreciate your deep research for explanations. And Garrett, you also, and Bruce, I can always count on you for the numbers. And I appreciate that very much. We had an incredible turnout for the CVO golf tournament just recently. The golf people are amazing. It goes into our helping hands. It takes us from springtime all the way through Christmas, building ramps and doing anything that's necessary to help the residents that need that help. So I appreciate all of you. I do want to do my bit here, Bruce. Much of what Facebook has posted is filled with malicious intent. A half-truth is dangerous because you don't know what half you're hearing. Facebook is not the forum for discussion with the trustee. You will not get your answers there, but an email, phone call, town hall, workshops works really well for an educated answer. Your questions are welcomed, or at least acknowledged, and hopefully we can answer them or find that answer for you. You, as residents, elect your trustees in a governmental election on the same ballot as federal and state officials. The trustees are your representative of Barefoot Bay's self-government. We all must live here. We are the recipients of all the same decisions that must be made. We feel it all just as you do. We live here. We experience these things. When you elect an official, you want them to represent you. Our Barefoot Bay government is the closest government that is close enough that you can come up and speak to us. Facebook would have you believing that we take no time to educate ourselves on all issues, that we just roll over and take commands. Hardly. When there is a legal issue, we need to know all the intricacies that are involved. And yes, we have more information from all sides, more so than the average resident. But again, this is not because the BOT is hiding information. It is generally because of legalities. We do have to make decisions that are far more difficult, but we have to have the minute details. Transparency always occurs within the limits of the law. And as an added reminder, we are not only Barefoot Bay residents, we volunteer for this position. You put us up here because I assume you know us, you trust us, or we wouldn't be here. And as far as the crooked workings and the under-the-table monies being exchanged, please let me know how, when, and where, because I need a new roof shortly. Coming to us with your concerns is expected. The vitriol is not, and it's unnecessary. I thank you all for coming today, and I ask that you trust in your vote. Accusations lead us into defending instead of conversation and communication. I also would ask that you reread the minutes for March 19 and March 24th. Many of the residents' concerns and ideas were addressed and acknowledged and added to our lists of projects. We hear you. We cannot handle it maybe that day, but we do listen and we put it forward into the agenda. So when the projects are criticized that we have all this money to spend is a fire pit, those ideas come from the community, and we are sharing those ideas whether we agree with them or not. We will have to vote on them at some point, but there are many, many things that will come forward that we will say, not this year, maybe next year. This is how it works. You put us up here. We're you. We are not strangers to this community. A gentleman mentioned that I spoke to a few people on the issue of the smoking. If anybody that knows me, I don't speak to a few people. I am at that pool all the time, every day if I can get in that pool. I go to every event. I am there on Fridays and Saturdays and Sundays. When I speak to people, I speak to everybody. And I don't know if Catherine is still here, but that was one of the ladies that I remember sitting down with, and she said, I don't like the idea of moving the smokers. I said, why? And she explained why. And I said, okay, what would you say to a compromise in putting the smokers, maybe we didn't make the right decision. What about putting the smokers back where they are originally going to be? And she looked at it and said, I think that's fine. That meets my criteria. I'm not just looking for people to agree with me. I'm looking for people to argue the point so that we can see all sides. I'm getting emotional, so I'm going to end there. But thank you all for coming. I do appreciate it. Please come to the town hall. Yep, this meeting is adjourned.